also around things like increased minimum flows. So the Plan Change 6 requires increased minimum flows. It's around flushing flows that would come from the water scheme. It's around riparian protection. It's around stock exclusion. So our principle is that the ecosystem health of the river is the fundamental measure, I guess, of freshwater quality in the river.
Can I just respond to 2 points there? Firstly, back to Peter's question. If I've got the answer correct, is that the reason the first bullet point is there is that you can't correlate directly the actions of an individual farm with the overall state of the river. That the tool for that is the LUC, and it's the LUCs collectively which do. So the accountability to the farmer is the LUC. If they meet the requirements of the LUC, they're then deemed to have been compliant. So we've got a two-step process. Have I got that correct?
That's right, and what the High Court judge has said is that second part, the deeming bit, is illegal.
Okay, so, but now the second point about this is that on the in-stream ecological health, I have a concern about this, and I want you to see whether I've got it right or not. All the things that you are talking about, flushing flows, minimum flows, riparian strips, stock exclusion, I agree with all of those. But they are external to the river. What we've talked about is about the micro, what are they, microinvertebrates? Macroinvertebrates, MCI, and the 0.8 is the tools that we've been, the 0.8 has been the tool that which measures the health of the river. So the way you have described this is that if we exclude stock, put riparian strips in, all the rest of it, then we have deemed to improve the quality of the river, not have the measures well. That's the way that was coming across then, and I had a problem with that.
So I think that just the fundamental principle. So we can move on and perhaps address your concern, but I think the fundamental principle is that we're trying to manage this catchment, these waterways, for ecosystem, ecological health.
Sure.
That's really what this is. All this is trying to say, albeit perhaps a bit too wordy and distracting. But I take your point about the biological indicators. So I'll move on then to the final three. So one of the other key principles for us, and recognising, Councillor Barker, your comments, is that biological indicators of freshwater quality are the appropriate indicators of ecosystem health. Ecosystem health is influenced by a number of factors, and so nutrient inputs, yes, but also temperature, whether or not there's shade alongside the waterway, obviously flow, sedimentation, etc.,
Yep.
all of which are location specific. So, one of our principles for this is that the biological indicators are the appropriate indicators of ecosystem health.
So just by location specific, you're not meaning catchment specific, you're meaning parts within a catchment, is that correct?
It could be both. It could be catchment specific, or it could be within a sub-catchment within that catchment specific. It'll depend on which pressure, which driver is at play at the time in that area, and what impact that is having on ecosystem health as represented by biological indicators like the MCI.
Thank you. Councillor Belford.
So when you combine a number of these together, the takeaway that I have from it is that we're planning to go to the Board of Inquiry, wink as we go in the door and say, yeah, we know we got that problematic DIN thing in there.
Order, Councillor. We're not
trying
a theatre. Just ask a question.
I'm trying to understand where this
you're not.
leads. Yes, I am. I'm trying to understand where this leads. What is our position going to be? This seems to be a set of principles that is geared to saying, basically, the DIN limit is irrelevant. We have a better mousetrap here, as we see it, for how to measure the ecological health of the river. And so we're effectively going to try to re-litigate what we've already lost.
I think, Councillor, if you go back to Ms Bromfield's comments and also back to those early principles, we do not intend to introduce any new evidence or indeed relitigate what's already in front of the board. We go back to the, in our minds, the draft decision of the board, which includes that 0.8 DIN limit. We're not intending that it be written out.
It's
So
the
that's-
existing-
We accept that it's that they've reached that conclusion based on the evidence that was presented to them throughout the hearings. But we also want it acknowledged in accordance with the National Policy Statement for Freshwater Management 2014 that ecosystem health is the primary measure by which we should be managing the waterways. We got kicked in the butt over the toxicity argument, and all the parties agreed that ecosystem health. We want to to ensure when we're discussing it with the other parties that you're in alignment with that as well.
I just want to be
Councillor
question
Barker.
here. I want you to articulate clearly to us that none of this is to in any way sideline, diminish the 0.8 DIN limit. That's the concern I have under this, because when you talk about all sorts of other things, I can't see in all of this. I can't see 0.8 stands as a fixed rule here, unmovable. That's what I'm looking for, and I can't see that.
We're trying to make a rule that, as I go back to earlier ones, that's practicable to implement and consistent with the MPS for freshwater management, that reflects all of these principles. We have gone back to, in our view, the baseline of the draft decision, which introduces the 0.8. It requires, and you recall the draft decision, consents from virtually everybody to run a farm. We obviously, some of our other principles don't accept that particular part of it, but we are not challenging, I'll repeat, we're not challenging the 0.8 DIN limit. Yeah, it's the implementation of it. Yeah.
My question went further than that, was not challenging it, but not trying to sideline or diminish it.
Can you explain then, please, what you mean by sideline or diminish?
Well, I can only do it by example, really. Some time ago, we gave the Reserve Bank 4 things they had to do. Maintain currency stability, and maintain...
Who's we, councillor?
The government required them to do 4 things, and whenever they were challenged on one of them, they said, well, we're doing the other 3. And in the end, we had an economic mix. So in the end, they changed it to say you've got 1 point and that's what you have to do. The issue I have on occasion, we have multiple targets. The regulator, in this case the Reserve Bank, could point to one of the others and said they're doing that. And so therefore things got obscured. This is the difficulty of having multiple targets. So my point here is that, I think here, if it's a single target, for example, 0.8, it's clear about that. But if we have managing the health of the river or something, well, could we at some point in the future say, well, yes, we haven't quite gotten to 0.8, but we're managing the health of the river. We haven't got to that because we're doing something else. In other words, the process is set up where you can sideline it and get around it. I want to be clear that we're not doing that.
So,
Our decision to make. that will be the decision of the Board of Inquiry.
But what I'm saying is we're not setting up for that to be an outcome.
Yeah, I go back again to that principle that it's got to be readily understood, practicable to implement, and consistent with the MPS 2014.
So,
working around the table, councillor Bevan.
so I mean, it's hard to argue with your first point up there, but my understanding of what the Board of Inquiry actually decided was that the indicator of ecosystem health was 0.8, not all of these other biological indicators.
Just to be clear, what they accepted was that an adequate indicator of biological health was the MCI score, and they accepted the scores that were proposed by council. And what they said was, they accepted the evidence of Massey University scientists that said, in order to achieve that level of ecosystem health, all you need to do is achieve 0.8 DIN. And so they didn't say 0.8 DIN equals an appropriate biological indicator or measure of ecosystem health. They accepted that MCI was the measure or the indicator of ecosystem health, and that to achieve those scores in Table 591B, I think it is, you meet 0.8 DIN. So the two are quite different.
So they actually decided, the Board of Inquiry did, that regulating for ecosystem health meets the MPS, but regulating for nitrates does not, or gives effect to the MPS. So that first principle there is quite consistent with that Board of Inquiry finding.
Councillor Scott, did you have your hand up? No?
I did, as the
Choice between the two of you, I think, at the time.
Was going down a particular pathway, that the High Court judgment in 30 does make it quite clear that the LUC limits are a means of controlling the nitrate nitrogen, and the DIN limits are concerned with the overall ecological health of waterways. So it seems to me appropriate to be focusing on that with this particular principle, is it not? Appropriate. That this is in
Talk us through
keeping with the High Court.
Okay.
So just
Talk us through the last point.
Yeah, I probably made the second to last bullet point when I was doing the introduction, just to, the early side, just around the resource consents for the Ruataniwha water storage are now in place. That water storage scheme has always been an integral part of our water management strategy for the catchment, and just really highlighting there that the ruling of the High Court judge on the 18th of December last year confirms the granting of those consents. Now that ruling was around the potential a request for recalling of this decision by one of the parties, and the judge declined that, effectively standing by his decision that he had not accepted their appeal to decline consent. So, and that has since not been appealed to the Supreme Court. So those consents are in place. The final principle there is that any future plan changes within our region, including the tank catchment, need to be framed under the 2014 National Policy Statement. So what we're going to have in this rewrite is a rule or a condition in a rule that's consistent or meets the 2014 MPS. The rest of the plan change is still 2011. So all future plan changes will have to meet MPS 14 and take into account the gazetted National Objectives Framework. So are there any questions about those last two at all?
Councillor Balfour.
On the middle one, my understanding is that, yes, the consents, as it were not challenged, but the High Court judge did indicate that the conditions would need to be reviewed, correct? So that, in fact, those consents could be implemented within the context of whatever the revised TJ, whatever TT1J wound up being, right? So there would be conceivably fresh conditions put on the RWSS scheme as a result of this.
Correct, and once the final version of TT1J is known, then HBRC, I'm sure, will work to align their consent conditions with those. Yeah, but you're right. I asked Leanne just to put them all together in a Word document so that you could look at them en masse. So Leanne, could I just get you to bring that up, please? So really the paper, the recommendation from the paper, if I go back to that, is that you receive the report that's really given you a report on the High Court judge's findings, given you the process by which we're now following, and also the obviously a verbal update since this agenda was sent out, and then finally gives you a set of principles that staff and council will then take as instruction around which we package any detailed response, and obviously are part of any negotiation with the other parties.
Just a follow-up question. The discussion on Friday, I think you said there would be a discussion. Will that be managed or chaired by the Board of Inquiry chair, or is that just a the first chat, how does that work?
The board has directed that the parties basically conference to see whether they can reach agreement. That process is being run by the parties, so an invitation has gone out from Martin Williams, who's one of counsel for HBRC, in discussion with the rest of the applicants' team, inviting representatives from Environmental Defence Society, Fish and Game, or the council, sorry, Fish and Game, and Forest and Bird, and the primary producer interest to attend that conference, which will be partly in person for those people who can attend and partly by telephone for those who are further afield. Some are based in Wellington.
It's a meeting of council, not of technical people, or is there a mixture?
I suspect there's going to end up being a mixture attending that meeting.
Councillor Balfour.
I mean, one would presume that since we and all the other parties have to file their, I think what it's called a indicative position on this by 4 o'clock tomorrow, that our preparations are further along than this list of general principles, and all will be made public tomorrow, or will be available to all parties, which effectively means it'll be public as of 4:01 tomorrow. Is that correct?
That's correct. Everything needs to be lodged with the EPA by 4 o'clock tomorrow. Whether it's available online by 4:01, I can't say, but certainly one would expect it to be by the end of the day on the EPA's
Right.
website.
And so we could, in effect, have been better informed in this discussion by looking, whether in public session or private, at what we actually have prepared to date. Could we not?
I mean, it still is in a draft stage, and obviously with when you adopt these principles, in whatever form they take, we have to check consistency with those as well.
Okay, any other questions?
We were having a discussion by way of questions before about engagement with the other parties, which you sensibly sidelined, Chair, so we get everything on the table. I agree with that. But I would like to come back to the point about engaging with the litigants. And yes, the Chief Executive is right, we're the defendants on this part, but effectively we have been the initiators all the way. and at some point we're going to be sitting down with them around the table discussing things, and I want to come back to the point, what have been the barriers to us engaging with Fish and Game and the other parties, just use Fish and Game as one of them, about resolving these issues, and I accept the point that you make, Chief Executive, that we're in a court case, but even when countries are in a state of war, they still have embassies and people still talk in the most difficult circumstances. And I would have thought that discussing issues with them and trying to find a way forward would have been a sensible thing to do as a matter of course. So what have been the barriers to, has there been a sort of a principled decision that we're not going to engage, or have there been actual barriers to us engaging? What is it we can do to engage with Fish and Game and the others to try and negotiate outside of the legal process a solution to this? Because at the moment we're just batting heads in court, which is expensive and not always the best way to resolve things.
Correct, and I go back to your comment about outside the legal process. We are firmly within the legal process at the moment. And I think that certainly, through the efforts of the likes of the Land and Water Forum and encouraging collaboration and things like that, I think, the tank process is a great example of that. But we are in a judicial process. We actually have a legally privileged position at the moment, as do the other parties as well. And I think that probably the barrier to that is a system that we're operating within, but certainly the board's given a clear direction or set out its clear expectation that we discuss, and I think that process, which will start on Friday, will actually open the door to further discussions and trying to get, it's clear that the board would like to get some kind of consensus around it, and I think that having that kind of assisted process will certainly help encourage that.
I'll make no more comment, but I just, by way of comment, say I think any engagement we can have with these other parties, informally, outside of this ongoing, would be helpful to us. And I've seen legal processes where, for example, families get to the family court, that you get before a judge, a legal process. The best solutions come out when people go out the back, have a cup of coffee and have a talk. That's what we've got to do. We've got to find ways in which we can engage and get these things sorted. That's my view about it.
And that starts Friday, I suspect, or would hope.
I hope so.
No, I'm ready to get to the recommendation. Actually, do you have another question, Councillor Bellman?
Just a final process question, I guess, as best you can. I mean, if there will be the conference that occurs on Monday, and what would you? I mean, I guess the timing of all further process here would largely hinge around whether the Board of Inquiry felt it did want to accept further evidence. Would that be your expectation? If they said yes, we want to hear more evidence, then we're getting into a whole process. If they say no, then it could be more abbreviated. Is that how you're looking at this?
That's my expectation of how it will play out. The broader the job that the board thinks it has to do, and if it considers that it might want to hear evidence, then the longer the time frame is likely to be for that process to take place with evidence being exchanged. If the board decides its job is more confined, then the timetable it sets for further steps may be more confined. But we should know within a few days of the conference what the board thinks the process is, and I would expect it will be issuing directions for whatever process it decides is appropriate at that point. Before the week is out, I'd expect so, yes.
To follow-up question to that, who's able to go to the conference on Monday? Do you know? Is it open to councillors or?
It's open
public?
to any member of the public.
So it's open to the public. Okay.
It is, but in terms of people who can make presentations to the board, they need to be a party to the board proceedings.
Right, let's get to the recommendations, I think, unless there's any further procedural questions or any other questions. So,
in terms of item 3, would the wording then become, or the proposed wording then become, agrees and adopts the principles as scheduled 1 to 8? Is that what you're looking for?
agrees and adopts, yeah, that is the change. Yes, thank you. So is someone happy to move that? You happy to move, Councillor Scott? Happy to second? Thank you. Wish to speak?
I'm grateful to the staff for having clearly formulated these. I must admit I struggled over the last few days to try and pull together some principles, but certainly these are, right along the line, and particularly the need for all rules to actually be readily understood and to be practical to implement is absolutely essential to any good rule writing as far as plain goes, because there should be no room for people then to contest the meaning of that particular rule, which has happened in the past with planes up and down the country. So to me that's a guiding principle that actually has to be there. I think everything else has grown out of what we have already agreed on with the Board of Inquiry's direction, and then finally it's totally in keeping with what the High Court judgment has indicated. So if we can adopt those, it certainly guides the staff. They may have drafted various things, but until they've got the principles to go by, then the actual wording cannot be properly wordsmithed until we actually have given them the direction that we want to take. I think these principles gives them that direction, and they've got a very tight time frame to actually get something adequately drafted and presented by 4 o'clock tomorrow. So I can see there are going to be some very busy pens.
Councillor Dick.
I'll reserve my right to speak, but I believe the wording should be in 3, agrees and adopts the principles, agrees and adopts.
So you reserve your right to speak. Hey, Councillor Bevan.
I just want to raise a point of order here. Is it possible for you to take these 8 recommended principles one at a time, because I will support some but not others?
I'm going to take them on block, because agrees and adopts says we're in, you're in or you're out.
I'll be voting against it, but
No, you need to speak now.
okay. Firstly, I want to express my disappointment that we have not engaged with the parties prior to the Board of Inquiry ordering us to do so. It really concerns me that we got our butts so badly kicked in the court case, and that we weren't prepared to go out and talk to the other parties, who at the end of the day want the same outcome as us, which is better ecosystem health in the Tukituki River. And I think we've left it so late in the piece. I'm really concerned that we're just going to find ourselves back in the middle of an adversarial process. So that really concerns me. I'm concerned with points. I can support 6 of these 8, but I can't support 3, because I think that we're, by trying to truncate and speed up the process, which is why we're taking the position we're not interested in having fresh evidence, I think we're not showing enough flexibility and not listening to the other stakeholders to this process, so I won't support 3. And I'm really concerned about 4, because it just seems to me that with regard to 4, that's precisely the reason why the judge found as he did, that he recognised that that the Board of Inquiry in its final decision had not given us as a regional council and the environmental managers of all of this any tools to manage the 0.8 in the river. And what we're trying to do is as a continuance of that, and I just think this puts us against the other stakeholders, and I won't support that either. So because you won't take them individually, I'll be voting against this.
Thank you. Other speakers? Councillor Graham.
I just want to endorse those comments from Barker and Bevan. I just think it's a huge tragedy that we've got ourselves into this situation, and that we've had to be instructed by a court to talk to other people in our community. And if you break this down, these people in fish and game and forest and bird, they're really important parts of our community, and we all know members and we all have families that are involved with them, and yet it took a court to tell us to go and have a chat. And some of the comments that Councillor Barker made about solving disputes by going out and having a cup of tea, and I'll have you know that I've been in more disputes than most people around this table, and I've always found that as soon as you get lawyers involved, it turns to custard. And even now we're going to have a conversation, but it's all going to be based around our lawyers. And yet I'm sure if we had have had the foresight right in the beginning to start talking to people in our community, we could have moved this thing forward a lot better. And now I see the emails that come across my machine, and there's now huge mistrust from these people about Hawke's Bay Regional Council, which I am party of. Not only huge mistrust, I would suggest there's huge animosity. So these are barriers that we have created. They didn't create it, we did, and these are barriers that's going to take some time to break down. And I don't think the kind of what are you calling it? Meeting that you're going to have, you called it something particular, is the right forum. We need to sit down with these people and say, how do we take our region forward? How do we take our farming forward? And yet we can still meet your objectives. And we've failed on all accounts to do that. Councillor Belford.
Like Peter, Councillor Bevan, I have most difficulty with items 3 and 4 here. But then when you even add in this sort of milk toasty number 6, what I feel this represents is it's leading us directly down the path that Councillor Barker most fears, that this is basically a instruction or a exceedance on our part to the staff to pursue a course of action here that as I see it has been rebuffed twice already, and we're doing so without even having tested any of our thinking or any of the waters with the protagonists who have prevailed against us twice now, and I just don't see how that's a prudent course to follow, or why we would do that. So, from my standpoint, these conditions are principles, if you will, are fatally flawed and are going to take us right back into the middle of issues that have already been relitigated. We're basically setting this up so that we can say, yeah, the DIN limit is in there. We're not challenging the DIN limit, but we're going to ignore it. And we're asking the board to go back to that position, which in its interim decision, if that's our starting point, they endorsed. So I'll be voting against this resolution.
Thank you. Could I just take an opportunity to speak here? I think we're beating ourselves up a bit on the basis that we've got a process governed by a board of inquiry. They have to deal with this. They will come out with the pathway that we will follow in the end. All we can do is, this is not the submission, but these are the principles that will guide it. And I think the conversations that follow are the important pieces to think about here. Whether the process is, could be over a cup of tea or not, I think we're past that. We're well past that. And the day will come where there is a resolution to this, one way or another. And we're saying these are the principles that we want our staff to present on. I'm not saying that, we've got a view, but others will have possibly different views. And it's up to the board to decipher all that and find a solution. And I think, it's happened very quickly. That is correct. It's sort of fortuitous that there was a council meeting just before the cut-off date of tomorrow. And I'm not sure where we would have gone if it was last week, for example, but I suppose we would have had a special meeting of some sort to work out some principles. But I'm still in favour of the process running its course, and I think it's very close to the end of its course now. So the board will have its own view, and I will respect that, and I anticipate watching the process wind on to its conclusion. Other speakers? Councillor Pipe, then Councillor Barker. Councillor Pipe.
Like you, I hope that this is getting to the close of a very long and difficult time, I guess, for all parties. The Board of Inquiry heard an enormous amount of evidence. I think it was almost a record, I think, for the amount of time that they spent and for the amount of evidence that was put before them. They came out with a draft report that was challenged. It went to the High Court. The High Court have raised some